Hello, everybody, and thank you for joining us. We'll be giving you a presentation on back to school issues that kinship caregivers can often face. This is the fifth of our six-part webinar series. Our last one is scheduled for August the 19th at noon, and we'll be discussing financial help, including public benefits and community resources. You can sign up for the remaining webinar or view previously recorded webinars on Texas Legal Service Center's YouTube link by going to tlsc.org. We just wanted to introduce ourselves. I am Nicole Love, and I am a staff attorney with the Kincare project here at Texas Legal Services Center.
And I'm Mary Doherty. I'm also a staff attorney with the Kincare project at Texas Legal Services Center.
Before we get started, we wanted to give you a little bit of background information on Texas Legal Services Center. TLSC is a statewide nonprofit organization founded in 1981. We provide services such as legal advice, advocacy, representation, and education to underserved populations throughout the state. We currently have over a dozen practice areas that are geared toward civil law issues impacting low-income Texans. The Kincare project is part of our child welfare team, which in addition to a managing attorney is made up of 5 full-time staff attorneys, actually 4 full-time staff attorneys, 5 in total, 1 part-time attorney, and 1 social worker. The team also staffs our family helpline, which is a free helpline that provides legal information around Texas Child Protective Services issues, and our Family Early Defense Network can connect low-income families or non-parent caregivers with attorneys if they are being investigated by CPS or in family-based safety services cases, commonly known as FBSS, or who need help appealing a reason to believe finding. We'll talk more about the helpline and the Family Early Defense Network at the end of this presentation. So we built this presentation because we know from working with kinship caregivers how incredibly difficult it is to get authority to make basic everyday decisions without a court order. The scale of this issue is massive. Latest available statistics show that in Texas, for every 1 child being raised by kinship caregivers in foster care, there are 24 being raised outside of the formal CPS system. But even for families who are connected to CPS, a caregiver's legal ability to make decisions remains strictly limited. This gap in authority directly impacts a caregiver and a child's day-to-day life, especially when dealing with schools. So today we're going to break down the most common school-related hurdles that caregivers face. We will cover how to navigate school enrollment, immunizations, medical treatments, special education, disciplinary actions, and how to deal with getting information from the school. As we mentioned earlier, we will wrap up by sharing resources. To kick things off with our first topic, I'm going to hand the presentation over to Mary.
Thank you. First, we'll discuss educational access and decision making. We'll start with general school enrollment requirements. Every child in Texas has the right to a free public education. The laws regarding enrollment and immunization requirements for Texas public schools are found in chapters 25 and 38 of the Texas Education Code. As a general rule, students must be enrolled by a parent, guardian, or a person with legal control under a court order. Now, this could mean the Department of Family and Protective Services, or CPS, if they have temporary managing conservatorship of a child, or this could include a kinship caregiver if there is a court order signed by a judge giving the caregiver custody, which is also known as conservatorship. Families must also provide documentation showing residency. This may include a lease agreement, a utility bill, or another document specified by the school district. Identification documentation, such as a birth certificate or other appropriate records to prove identity, are also required for enrollment. As a side note, if you need information on obtaining identification documents, please see our Kincare webinar from last month, in which we discuss obtaining identification documents. The videos of our past webinars are available on our Texas Legal Services Center YouTube channel. Finally, families enrolling children must provide the required immunization records. So if a kinship family is unable to meet the general requirements for enrollment, what can they do? Well, there are other options. Texas Education Code Section 25.001J states that a school district may allow a person showing evidence of legal responsibility for a child other than a court order to substitute for a guardian or other person having lawful control of a child. So, one way to do this may be through an informal power of attorney. An informal power of attorney could take many forms, but is essentially a written document signed by the parent or someone with legal authority to enroll the child in school that gives the caregiver permission to enroll the child in school. Many school districts may have their own form that can be found online. Other more formal options may include a Texas Family Code Chapter 34 authorization agreement for non-parent caregiver or a Chapter 35 temporary authorization for care of a minor child. To be clear, any of these may give a caregiver permission to enroll a child in school, but none of them gives a caregiver custody or guardianship. A Chapter 34 authorization agreement for voluntary caregiver is an excellent way for a parent to legally give permission to a non parent to make decisions that will allow them to care for the child. This allows the caregiver to do the things listed here, including enroll the child in school or daycare. Please note that at least one parent and the non parent must sign. A copy of the signed form must usually be mailed to the other parent. The Chapter 34 authorization only requires court approval if there's already a court order regarding this child, such as a divorce decree or an OAG child support order or another order in suit affecting the parent child relationship, or if there's a pending court case related to the child. This document works well when a parent or both parents agree for the caregiver to have permission to make decisions and to take the actions listed here. This does require a separate form for each child. It must be notarized. Unless there's a specific expiration date, the authorization automatically renews every 6 months until it's revoked, and it does not grant custody. You can find more information about Chapter 34 authorizations, including instructions and forms, on texaslawhelp.org. If a Chapter 34 authorization isn't an option because the parents cannot be found or are not willing to sign one, a Chapter 35 temporary authorization for care of a minor child might be a solution. A Chapter 35 temporary authorization is a formal request filed with the court. It can be used if the child has lived with a caregiver for at least 30 days, if there's not already a written authorization agreement or some other signed document that enables the person to provide the necessary care, and the parent, conservator, or guardian does not object to the person having the authority to care for the child. So essentially, the person requesting the authorization must demonstrate to the court that it's necessary. For example, it's needed to enroll the children in school or daycare, or to authorize extracurricular activities, or to authorize other care that's essential to the child's welfare. You can see the other things that the court may authorize the caregiver to do here. They're listed at the bottom there. Now, there are limits on who can get this temporary authorization. It must be either a grandparent, an adult sibling, an adult aunt or uncle, or an adult who has a medical consent authorization. And the person must have been caring for the child for at least 30 days. This expires after 1 year, but it can be renewed for another year. Again, information about Chapter 35 authorizations can be found on texaslawhelp.org along with forms. And again, this type of document does not grant custody. All right, next we'll touch briefly on ESSA, which stands for Every Student Succeeds Act, and the McKinney-Vento Homeless Assistance Act. ESSA is the primary law for U.S. public education. Its main purpose is to ensure all students, including those from disadvantaged backgrounds, receive a quality education that prepares them for college and careers. ESSA provides youth in formal foster care with certain special protections for school stability and school access. However, these protections are only extended to children and youth in formal foster care and not to children and youth in informal kinship care. However, children in informal kinship care may qualify for protections under the McKinney-Vento Homeless Assistance Act. McKinney-Vento entitles homeless children and youth to certain rights and services and ensures that they may receive a free and appropriate education with any barriers to that education removed. For kinship caregivers who do not have a court order, a power of attorney, or a legal authorization to enroll the child in school, McKinney-Vento may be a solution. It's a federal law that applies to homeless children and youth. The definition for what qualifies as homeless is broad, and it includes children and youth who are sharing the housing of others due to loss of housing, economic hardship, or a similar reason. It doesn't necessarily mean a child or youth is living on the streets. It can mean that they're living with a caregiver and away from their parents. A person defined as homeless under McKinney-Vento is entitled to admission, regardless of the residence of the person, of either parent of the person or of the parents or of the person's guardian or other person having lawful control of the person, and may not be excluded from enrollment due to the lack of authorization, agreement, power of attorney, or any other similar document. So simply put, a child who qualifies as homeless under McKinney-Vento is entitled to immediate admission in any Texas school district. The main takeaway for caregivers to know is that McKinney-Vento exists and to go to the school district's McKinney-Vento liaison to see if the child qualifies. There's a liaison for every school district. If the person at the front desk doesn't know what you're talking about, reach out to the administrative office and ask for the McKinney-Vento liaison or the homeless liaison. The protections for children and youth qualifying for McKinney-Vento are listed here. They include immediate school enrollment without the normally required documents, enrollment and transportation to the school of origin, immunizations, immediate enrollment into free school meal programs, school supplies and uniforms, extracurricular activities and fees. And as far as extracurricular activities are concerned, it shouldn't matter when the student starts school. They should still be able to participate in the extracurricular activity, even if it's the middle of the school year. And it also addresses needs arising from domestic violence, parental mental health, or substance abuse issues. Homeless students should not face barriers to accessing academic and extracurricular activities. Enrollment is defined as attending classes and participating fully in school activities. Again, a kinship caregiver can connect with the McKinney-Vento liaison to discuss whether the child or youth qualifies as McKinney-Vento eligible and discuss the protections they're entitled to. The school should provide a link to information on what McKinney-Vento provides, or the liaison or coordinator should tell you. All right, next I'll turn it back over to Nicole.
So we're going to talk next about immunizations and medical treatment. Texas, under the Texas Administrative Code and the Texas Education Code, requires children to be fully vaccinated against numerous diseases for school and daycare enrollment and attendance. So I wanted to quickly talk about getting kiddos registered for school. specifically regarding their vaccine records. Without legal custody, a kinship caregiver might face barriers with enrollment due to lack of vaccinations or just simply getting medical treatment for the kiddos in their care. So we know that for anyone tracking down medical paperwork, it can really be a real headache, much less for folks who suddenly become kinship caregivers. In Texas, there's a helpful rule called provisional enrollment. Essentially, what this does is it gives a caregiver a 30-day grace period. The child can start school right away as long as the caregiver can show proof that they've received at least the first dose of each required vaccination. However, if the child doesn't get the remaining doses within those 30 days and become compliant or up to date, the school will have to hold them out of class until they're all caught up. If a caregiver has absolutely no shot records at all because of how the child came to the caregiver, the best thing that a caregiver can do is go to the school's registration or administrative office. Under federal law, the school must connect the caregiver with their McKinney-Vento liaison, as Mary just talked about. They're required to help track down the old medical records, or they will work with the caregiver to get the child vaccinated for free or low cost at a local Texas Department of Health office. What else can a non-parent do if they have trouble locating shot records or the child needs to get updated vaccinations or other medical treatment? Can a non-parent give permission for vaccinations or other medical treatment? So the simple answer to this is yes. As Mary talked about before, under the Texas Family Code, parents can sign uh, a non-parent caregiver authorization agreement to give a non-parent formal permission to consent to immunizations and enroll the child in school. If the parents are unavailable or unwilling to sign a voluntary form, Chapter 35 of the Texas Family Code allows caregivers to make that formal request to the court for an authorization order that grants those specific permissions. Um, Additionally, if CPS is involved, there are some times when they may also be helpful in trying to get one of those Chapter 34 authorizations. We want to emphasize again that these do not transfer any parental rights. They are simply permissions to make these decisions. A third option for some caregivers is the form under Texas Family Code Chapter 32 called a consent to medical treatment by a non-parent. And we're going to talk more about this particular form. Under this section of the Texas Family Code, the law allows certain people to complete and sign a form to consent to medical, dental, psychological, and surgical treatments, which includes vaccinations, if the parents cannot be contacted and they have not objected. So, what non-parents can give permission for vaccinations? Texas Family Code section, specifically 32.101, allows a wide range of extended family and caregivers to authorize vaccinations for a minor if a parent or legal custodian is unavailable. This includes grandparents, an adult sibling, an adult aunt or uncle, a step parent, a school, an adult who has actual care, control, and possession of the child as the child's primary caregiver, or who has written authorization from the parent or other person authorized to consent, a person with a court order, including one from another state, or a court who has authority over the child. Someone giving permission under this section must also give the healthcare provider as much of the child's health history as they can so that the provider can determine the risks and benefits of the immunizations. So, what non-parents can give permission for medical treatment? The Texas Family Code also gives a wide range of people permission to consent to medical treatment if a parent or someone with the legal right to do so isn't available and again has not expressly objected. The list here is somewhat the same as the vaccination list. Again, you've got a grandparent, an adult sibling, an adult aunt or uncle, a school if the child's enrolled and the school has received written authorization from a person who has the right to consent, a court who has jurisdiction, which means control over the child through a court order, an adult who has actual care, control, and possession of the child and has written consent, an adult ordered responsible for the child under a juvenile court, and a peace officer who's lawfully taken custody of the child if the officer has reasonable grounds to believe that the minor needs immediate medical treatment. It's important to know and remember that even if a non-parent is allowed to give consent, they cannot, by law, give that permission if the parent has specifically refused to give permission, told the non-parent not to give permission, or withdrew the consent. However, if a child requires emergency care, so if there's an imminent threat of death or severe bodily injury and a parent or guardian isn't present, medical staff can treat a child, and once stabilized, they'll seek informed consent for any ongoing treatment that may be necessary. So I put a picture here of the Chapter 32 form. It's pretty simple. It includes the minor's name, the name of both parents. If both parents are known, sometimes one parent may not be known. So you don't have to put in the name of someone that you don't know, the name of the person giving consent, and the relationship to the child. You also have to include what type of medical treatment is to be given and the date the treatment is to begin. Uh, the nice thing about this form is that it requires only the consenter's signature. So no parent has to sign, um, and no notary is required. This form can be found on texaslawhelp.org. Can a minor consent to their own vaccinations? Generally, a minor cannot consent to their own vaccinations unless they fit into one of these two categories. If the minor's pregnant, or if they are the parent of a child whom they actually have custody of, and the Center for Disease Control has recommended or authorized the initial shot be given before the child is 7. So I think the key to that is actual custody. Can a minor consent to their own medical treatment? The answer to this one is sometimes. Under Texas Family Code 32.003, a minor can consent to their own medical treatment under certain circumstances that we listed there. The most common way for a minor to qualify under this section is the one in italics. If a child is 16 years of age or older and they're living separate and apart from their parents, their managing conservator, or their guardian, again, a conservator is someone who's gotten custody through a family court. A guardian is someone who's gone through a probate court situation, um, and they are living apart from either their parents, their managing conservator, or their guardian with or without consent, regardless of the duration of the residence, and who is managing their own financial affairs, regardless of the source of the income. So that means if a kiddo is 16 years of older and is living apart, they may not have gotten consent, but maybe they're living with a grandparent or a sibling or another caregiver, and maybe they've only been there for a couple of weeks, but they have a part-time job or some other source of income, they would qualify under this section. Can a minor consent to counseling? Yes, they can consent to counseling if it's for suicide prevention, chemical addiction or dependency, or sexual, physical, or emotional abuse. An adult is not responsible for the payment if the child is the one that's consenting to the treatment. If a child's permitted by law to consent, an adult does not have to give permission. I think that's one of the major takeaways here. The child simply has to sign their own consent form. Some doctor's offices or front desk personnel may not know or understand this and may need to be provided with a copy of the actual law, which is one of the reasons why throughout this presentation we've put those sections for you so that you could Google them or look them up and print out a copy of those laws if you need them. A lot of hospitals already have these policies in place and printed out for their personnel to make things easier. It is important to know that the provider can tell the parents or adult conservator or guardian about the treatment that's given or needed without the child's consent. Another important takeaway is that a minor can be examined without anyone's consent if there is a reasonable belief of abuse or neglect, unless the child is 16 or older and refuses the exam, or if there is a court order that prohibits the examination. So the next thing I wanted to talk about is special education. Navigating the school system as an informal caregiver is really tough. The data shows that about 21% or about 1 in 5 children being raised by informal caregivers face learning, behavioral, or development challenges. But because informal caregivers aren't part of a formal CPS case, meaning that the court is not involved, there may often be challenges when it comes to requests for special education services, participation, and decision making. And a caregiver's opinions might not be considered in making things like behavior plans. In Texas, all children have a protected right to an education regardless of disability through a federal mandate called Child Find, which is enforced by the Texas Education Agency. Schools must actively locate, evaluate, and support students who need extra help. Under the Individuals with Disabilities Education Act, also known as IDEA, this guarantees all children a free, appropriate public education, which you might also hear called FAPE, which includes free, custom-tailored instruction and therapies to help kiddos succeed in school. Despite recent federal administrative restructuring, students with disabilities retain the same rights. Disability Rights Texas has a really good information packet on these laws on their website, which can also help a caregiver navigate different issues, such as requesting an evaluation if a caregiver believes one is necessary. And these free services can include specialized instruction, speech therapy, transportation, um, all kinds and sorts of things. So under IDEA, the Texas Education Agency recognizes kinship caregivers as parents for the purposes of making school decisions. This definition is crucial because people under this definition hold exclusive educational decision-making rights or permissions to ensure that the child receives a free, appropriate public education. Again, FAPE guarantees that students with disabilities are provided special education and related services at public expense under public supervision and at no cost to the parent. These services must meet state standards, be tailored to the child's unique needs, and be explicitly outlined in what's called an IEP or an individualized education program. The term parent legally grants the following rights regarding FAPE: participation, which means the right to be a mandatory member of the IEP team that develops, reviews, and revises the child's educational program. Placement, the right to be included in any group that makes educational placement decisions. And consent, the right to provide or refuse consent for initial evaluations and initial provision of special education services. This also includes advocating for reasonable accommodations and services under Section 504. If a kiddo doesn't maybe qualify for special education services. So the takeaway here is if a caregiver has physical possession and is acting in place of a parent, that caregiver should meet the federal IDEA definition of a parent, provided no biological parent is actively contradicting those choices. If a biological parent is active and holds different opinions, if a caregiver doesn't have legal custody, the school is going to listen to the biological parent. But it's really important to know that definition and know that no custody or authorization is required for a kinship caregiver to participate in the child that they're caring for in those evaluations or services involving special ed or 504. And now I'm going to turn it back over to Mary.
Next, we'll touch briefly on discipline and corporal punishment. Corporal punishment is defined in the Texas Education Code as the deliberate infliction of physical pain by hitting, paddling, spanking, slapping, or any other physical force used as a means of discipline. Texas is only one of 18 states that still permit corporal punishment in schools. Studies have shown that corporal punishment can contribute to decreased academic performance and engagement and more disciplinary issues. So wanted to talk a little bit about opting out of corporal punishment. First of all, under the Texas Education Code, Chapter 37, it states that if a school district adopts a policy permitting corporal punishment as a method of school discipline, a district educator may use corporal punishment to discipline a student unless the student's parent or guardian or other person having lawful control has opted out. And let's talk about what opted out means. To prohibit the use of corporal punishment as a method of student discipline, each school year, a student's parent or guardian or other person having lawful control over the student must provide a separate written signed statement to the Board of Trustees of the school district in the manner established by the board. So essentially, if a parent or caregiver wants to opt out of corporal punishment for their student, they have to provide a signed and written letter or document that meets the requirements of the school board. The issue for non-parent or kinship caregivers is that they may not have authority to opt out of corporal punishment if they don't meet the definition in the statute. So there's no exception unless the child is in formal foster care or the caregiver has a form of lawful control, which could be a court order or something such as the Chapter 34 authorization or the Chapter 35 that we discussed. There is no specific exception for McKinney-Vento children. So, what can a caregiver do if they do not want their child to be to receive corporal punishment, but they don't meet the definition of a person that can opt out? Well, there are a few options that you might be able to try. So first of all, the Texas Education Code requires every campus to have an on-campus behavior coordinator. They must consider the mitigating factors, including intent or lack thereof, disciplinary history, and whether a child has a disability that substantially impairs the student's ability to appreciate the wrongfulness of the conduct. For families of students with disabilities, you should know that a good resource for school discipline information and support is Disability Rights Texas, and we have included their information in our resources at the end of the presentation. Another thing to remember is that McKinney-Vento prohibits a student from being stigmatized on the basis of homelessness. So one thing you could do is speak to the on-campus behavior coordinator and try to relate the behaviors that the student is being disciplined for to the homelessness that they have or are experiencing. So for example, if a child is regularly being tardy or absent, but it's outside of their control because of the situation that they're in, or by the fact that their caregiver doesn't have a vehicle to get them there on time, or if they have if they're being disciplined for behavior in which they were reacting to statements that someone made about their clothing or their hygiene, and if that could somehow be related to their situation that makes them qualify as McKinney-Vento, that might be something that you could use to persuade the behavior coordinator to use a different type of discipline other than corporal punishment, or to allow them not to be penalized for the behaviors that they're exhibiting that are related to the trauma that they've gone through. Finally, we'll touch briefly on release of information. So FERPA stands for the Family Educational Rights and Privacy Act. FERPA is a federal law that protects the privacy of student education records and grants students and parents specific rights regarding access and disclosure. So FERPA was enacted in 1974, and it applies to all public and private schools, K through 12 and post-secondary, that receive funding from the U.S. Department of Education. Its primary purpose is to protect the privacy of personally identifiable information in student education records and to ensure that students and parents can access and control the release of these records. In FERPA, the term parent has a broad definition, meaning it can be more than just a biological or legal parent. The definition is a parent of a student. The definition includes a natural parent, a guardian, or an individual acting as a parent in the absence of a parent or guardian. The takeaway here is to know that kinship caregivers may be entitled to student education records and information under the definition of parent if the caregiver is acting as a parent to the child in the absence of a parent or guardian. Next, we'll share some resources that may be helpful to kinship families. First of all, we have the Texas Legal Services Center Kincare project, which is the project that Nicole and I work for. It's a statewide project that helps Texas caregivers of related or non-biological children gain long-term safety and security by providing legal advice, limited representation, and in some cases, full representation. The types of things that we can help with include limited assistance in uncontested suits for obtaining legal conservatorship or custody, assistance with obtaining authorizations, assisting with education and access issues for children in their care, obtaining identification documents for children in their care, accessing government benefits, navigating Social Security issues, and obtaining kinship benefits through CPS. Now, on this last item related to kinship benefits, what we mean is providing post CPS case advice and assistance to help kinship caregivers explore PCA eligibility, verify signed successor agreements, and access entitled benefits. We don't get involved in cases where CPS has a court case pending. Here are the eligibility requirements. An applicant must be a non-parent caregiver who has possession of the child. They must be a U.S. citizen or a lawful permanent resident and a Texas resident. The household income must be at or below 125% of the federal poverty guidelines. Just a note on that, we currently have a grant that allows us to go up to 200% of the federal poverty guidelines, but that grant is going to be expiring in about a couple of months. So we only have a very short time where we can still assist people up to the 200% of the federal poverty guidelines limit. And CPS involvement is not required. There doesn't have to be any CPS involvement for us to assist in someone's situation. The way that you can apply is by going to Kincare at TLSC.org or by calling us at 512-477-6000, extension 216. And so just a reminder, if you need help with any of the issues that we discussed in our presentation today and you believe you may qualify, please feel free to reach out and apply for services with us at the Kincare Project. Next, I want to tell you about the Family Helpline, which is another program through Texas Legal Services Center. There is no income limitation, and anyone is free to call and receive free legal information on the topics of child protective services in Texas, child abuse, or child neglect. Again, anyone can call, not just parents. And also, the Family Helpline is completely anonymous. The helpline operates Monday through Friday, 9 to 6, and the number is 844-888-6565. To learn more about the Family Helpline, you could also check out our website at tlsc.org/family. Here are a few other resources we just want to make sure that people know about. Texas Law Help. We've referenced that a few times throughout our presentation today, and it is a great place to find legal information. This is another project of Texas Legal Services Center, and it can be especially helpful to people who are trying to represent themselves in legal matters. The website will also allow you to chat with an attorney from 10 a.m. to 2 p.m. Monday through Thursday, and they can often answer questions or help point people in the right direction. And the web address is texaslawhelp.org. Another great resource is the Texas Kincare Guide. This was developed by the child welfare attorneys at Texas Legal Services Center to help kinship caregivers get the information they need to successfully support themselves and their families. The easiest way to find it is to go to texaslawhelp.org and search for Texas Kincare Guide. The DFPS Kinship Manual is a useful manual for kinship caregivers who have had children placed with them by Child Protective Services. And there's a link there that you can follow to find that. Another resource is Texas Free Legal Answers. It's a virtual legal advice clinic in which qualifying users post civil legal questions at no cost to be answered by pro bono attorneys licensed in their state. Next is Family Help Link. This is an online resource on texaslawhelp.org that will allow people to follow prompts and get connected with programs that match their needs. And then I also want to mention FEDN, which Nicole had brought up at the beginning, which is the Family Early Defense Network. This offers free legal representation for parents and caregivers facing CPS involvement in their families, including investigations, family-based safety services, or administrative reviews of investigative findings. We partner with the other 3 big legal aids in Texas to provide representation to people earning less than 125% of the federal poverty guidelines. People who need this service can apply through the Family Help link or by calling the Family Helpline. And finally, we provided the link for Disability Rights Texas. They have some great resources, and I believe that we had referenced them a couple of times in our presentation today. So if you want to see what information and services they provide, you could check out their website. It's disabilityrightstx.org. On behalf of myself and the child welfare team here at Texas Legal Services Center, we appreciate you taking time to attend our webinar today. To the Kinship Caregivers, thank you for the good work that you do every day and the difference that you're making in the lives of the children that you care for. We hope that the information and resources we shared today are helpful to you. Thank you.